Hi, everyone, and welcome to another episode of Talking Law. Today, we're going to be talking about how do you settle your off-the-plan contract? It's a very important question that needs to be answered properly. We are the experts in off-the-plan contracts at Pre-Alla Legal. We've been doing this for more than 20 years. So we are perfect to be able to tell you exactly what you as a buyer need to do to be able to settle your off-the-plan contract. And we're going to take the time in this episode to explain why is it so important that you settle on the settlement date that's scheduled for you, and how do you get there? And there are many steps that need to be taken so you can actually settle on the date that you're supposed to settle. And we're going to talk about what happens if you don't settle on that settlement date. So it's pretty critical that you listen up, and we will be giving you all of the information that you need in this episode to let you know, well, how do I actually settle my off-the-plan contract? So I suppose what's really important to mention up front is, first of all, I think, why is it important that you effect settlement? And this is in relation to Queensland off-the-plan contracts, because Queensland is a little bit unique to other states around Australia. And we act for many clients across all states and territories in Australia, as well as overseas. And we have found over the years there is a uniqueness, of course, to Queensland law. And this uniqueness is all about time being of the essence. And it's important to just spend a few moments to explain what that means, because we are different to other states, and it is critical you settle on the settlement date. So understanding how important it is very relevant to then talking about how you actually settle your off-the-plan contract. So in Queensland, we've had this concept for many years. It's called time of the essence. What that really means is they can never take for granted that if they can't settle on that settlement date, that they'll just get an extension given to them by the developer. That's very critical to understand. Many buyers from interstate have that misunderstanding because in those states where they've come from, the laws are different. But in Queensland, we are unique in that respect. Now, in saying that, it doesn't mean that you can't ask for an extension, but you should never assume that one will be granted. What you need to do as a buyer is make sure you take all the relevant steps with your lawyer to make sure that you actually are ready to settle on the settlement date. Because when it comes time to settle, the crunch time, if you are actually not ready and you are putting your hand up for that 1 day extension, most likely 99% of the time, the developer will not grant that extension because they do not have to under the contract. So, and if they do actually give you an extension, which can never be assumed, then you will be hit with things like default interest, covering their legal costs for the extensions, and so on. So, first of all, never assume you'll get one. Second of all, always work towards settling on that settlement date. And thirdly, if you are given an extension, then you're going to be hit with conditions, penalties, interest, costs, etc. So it's never a good position to be in as a buyer if you actually can't settle. So now, with that out of the way and explaining it is always critical to be ready to settle on the settlement date, let's talk about now what happens at the pointy end and how many steps or stages are there to actually getting to the settlement date. And many of those steps or stages are ones that the developer has to take. You as a buyer are sort of sitting in the background waiting. But if you have an experienced lawyer acting for you, like us, we can explain to you 2 or 3 months out of what looks like practical completion as to what the whole process looks like, what will be involved, and the approximate timeline. Now, these are things that we always explain to buyers from the beginning. Prior to signing a contract, we always explain the timeline, and the timeline for an off-the-plan contract, generally how it works. I think it's important myself personally for our clients, our buyers, to understand the process of an off-the-plan contract. So they actually really have a very good understanding of what's involved in getting into an off-the-plan contract from the beginning to the end. So firstly, We've talked about sunset dates before, so hopefully you've listened to that episode. If you haven't, jumped onto my YouTube channel, listen to the sunset date episode, which is really important to listen to, whether before or after this episode, but it really should be listened to in conjunction with this one. But this one, I just wanted to focus on the steps required to get to settlement on its own, because it's really, really critical and important to understand, as I've said a few times already. So if you're living in the state or near where the project is at, it's going to be easy when I say to you as a buyer, look, drive past the site regularly, which you would be able to do if you live here, and you'll be able to see from a physical perspective what the project is looking like and when it looks like nearing completion. Now, one of the telltale signs is when the scaffolding starts to come down from outside that building. So that is a telltale sign, but more difficult, obviously, if you don't live near the project or in the state. You can't just drive there. You live interstate or overseas, and therefore you're relying on construction updates from the developers' representatives, which most likely or most often come from the selling agents themselves. Sometimes it comes from the developer's office themselves. But we don't really, it's rarely we get the construction updates when we act for buyers. So you will get the construction updates before we do. And it's important to read those construction updates. But obviously other things like pick up the phone, talk to the agent that sold you the lot. If that agent is no longer there, talk to the selling team, find out and write down for yourself a record of when you spoke to them, the date, the time, and what the actual update was given to you at that particular time. It really is within the developer's interest to obviously update their buyers, which is why I say to buyers, well, one would hope that developers give constant, regular construction updates to make sure their buyers are getting ready for settlement. So most of them give them, not all. So that's why it is important to be proactive from your end. And the reason is that often when I talk to buyers, right at the beginning, one of the critical questions I ask them is, how do you intend to fund the balance of the purchase come settlement time? Now, that may change from when I talk to them to when the project is complete, but that conversation is important because a lot of things get flushed out from that question I ask buyers. And usually it's one of three things. They have to sell a property that they have, whether it's their primary home or an investment property. They have to get a loan to be able to fund the purchase, or they've got actually cash sitting there ready to use, or they know that a large payment of some description, maybe the selling of shares, etc., will be coming into their account in the future. Or it's a combination of all of those things. Now, we document that from the beginning, and it's important for us to talk to buyers about what that means come settlement. Now, obviously, this is part of the risk analysis. If you're needing to sell a property, if you're needing to get a loan, those two things particularly, obviously you need to be able to sell that property in time and get that loan sorted before settlement is called. And how do you do that? So this is why I talked before about practical completion. Practical completion is one of those triggers that everything flows from. So when the scaffolding comes down, it's a telltale sign that the project's nearing practical completion. And when it has reached practical completion, the developer's got to do quite a few things to get to that day where they can call for settlement and send notices to buyers or their lawyers to say, well, it's ready, it's time, we're settling, here's your notice period. And we're going to talk about what that looks like in a minute. So at that point in time, when you know that it's nearing practical completion, so we say hopefully that's 2-3 months out of the potential estimated date of completion, then you would have already spoken to your bank, hopefully, get all your ducks lined up in a row, have everything sorted with your financier. So all they need to do is wait for that lot to be registered, get the title issued, and then do a valuation, of course, on site, and then issue security docs to you. And these days, most funders allow electronic signing of your security documents. So that will fast track the time period involved. So really important to talk to your bank early on. If you don't talk to the bank at all until that settlement notice, the calling of settlement, your funder will have no time to settle. So it's critical to get those steps to be taken and be ready at least 2-3 months out of what looks like nearing completion. Now, if you're selling a property, again, probably a bit more time is needed, maybe 4 or 5 months, to put that property on the market, find a suitable agent, get it listed, get it sold. Now, some people say, well, in this market, things are selling pretty quick. Sure, but that's not always the case. And it does depend on where your property is at and the location of that property as to how quickly that property will sell on the market. But again, make no mistake, you've got to be ready. So get all those things done early. It's far more difficult to move from your primary residence that you live in directly into an off the plan. I've mentioned that before in prior episodes. Really difficult, almost impossible to actually navigate that where you move from one directly to another, because you won't know the settlement date of your off the plan until 14 days notice is given. So let's explain that a bit more. So we have the telltale sign of the scaffolding coming down, the nearing of the practical completion. Now, the developer has to do a few things. He's got to get his certificate of occupation. Okay, so this is a really important point. There are and have been some projects on the Gold Coast that I have acted for buyers in, where the developer has called for settlement without a certificate of occupation. Now, how do we know this? This comes back to you getting pre-contract advice. So when we go through the contract, we make sure the contract actually says that a precondition or a condition to calling for settlement, put it simply, is that the certificate of occupation has to be issued, and the buyer is entitled to see a copy of that. Now, without the certificate of occupation, lawful occupation of the unit or the lot can't occur. So technically, a developer really shouldn't be calling for settlements unless they have a certificate of occupation. But as I said, I've experienced this firsthand on a particular project at Palm Beach, where the developer called for settlement, and when we inquired, well, where is your certificate of occupation? There was none, and they were still waiting for that to be issued. So that is a very, very relevant point. And what we had to do is argue, unfortunately, because of the particular developer and the lawyers involved, and argue the points quite extensively to actually get the extension without any penalties, of course, to our client, to point out that you can't actually have a buyer settle without a certificate of occupation. You can't be doing that. It's not lawful, etc. So once we argued the point, of course, we were able to get those valid extensions given to the buyer until such time as a certificate of occupation is issued. And that brings into discussion another point. I mean, some people might think, well, when practical completion is reached, doesn't that mean the certificate of occupation is issued? No, not necessarily. And sometimes you'll find that there is a bit of a delay in getting that certificate issued. So it is very critical that with the pre-contract advice, does your contract actually say the developer has to hand it over? Because if it doesn't, put your hand up and ask for that variation to the contract from the beginning. And hopefully it does. So then when you get to the pointy end, you can certainly put your hand up and say, well, hello, I'm not settling unless you give me a certificate of occupation. Because believe it or not, that project I mentioned before at Palm Beach, the developer somehow expected the buyers to actually settle and for the buyers not to actually be able to live there with no doors, handles, no doors, no locks, no keys, no nothing, because none of that was completed and the certificate of occupation had not issued. So it was very bizarre, but nonetheless, that's why you need someone experienced to deal with these little sometimes bumps in the road, I'll call it, when getting to the pointy end of a settlement of an off-the-plan contract in Queensland. So let's keep going. Certificate of occupation must be issued. Okay, then what else does the developer have to do? Nothing to do with the buyer, but the buyer should understand what the process is because it all comes down to timing. So the other critical thing is, of course, is to get council, local council, to seal that plan. Now, what plan am I talking about? So in your off-the-plan contract and disclosure document, the buyers at the beginning, you would have been given the proposed plan. So the proposed plan for the proposed lot. Now, when they get to practical completion, there will be a plan that is finalised by the surveyors and other consultants. And that plan has to have the green tick of approval, I'll call it, from council. Now, council has to seal that plan. Now, from the time the plan's lodged with council to when it comes out of council to have it sealed, who knows how long that takes. A typical time frame is about 4 weeks on the Gold Coast and in Brisbane, but sometimes that time is extended because the developer has to meet a number of conditions perhaps they didn't expect, and they have to deal with those conditions. So sometimes it's dragged out for more than 4 weeks, sometimes not, sometimes it's less. So let's work on a benchmark of 4 weeks, maybe 5. And then once the plan comes out of sealing, hopefully the developer's lawyers at that point send your lawyer a notice, oh, by the way, the plan's sealed, and now we're going off to lodge it with Queensland Titles. So that's the next step. So the plan is lodged with Queensland Titles. Now, a typical turnaround time frame from the time a plan's lodged with Queensland Titles to when it actually comes out registered is, say, 2 weeks. So that's pretty good benchmark to work from. So you can see you're sort of looking at 4 to 6 weeks from the time perhaps that we know that the plan's been issued with council for sealing to when it might come out of titles for as a registered plan. And that's important because when that plan is registered, and if it's a building, there'll be a body corporate. So when the community management statement is also registered, there's a scheme established, and there are individual lots created for that building and individual titles, then the notice for settlement is issued to buyers and their lawyers. And that settlement notice is typically a 14-day turnaround time for settlement. So it's a strict 14 days. It's not, oh, maybe 14 or 15, give or take. No, when you get the settlement notice, it's settlement is 14 days from this date. And that's when settlement is required. Now, in that process, what I really don't like and what happens a lot on the Gold Coast is that that particular settlement notice is often issued to buyers' lawyers at 4 or between 4 p.m. and 5 p.m. on a work day. And that means that that whole day then is lost. So it's really 13 days. And I don't really understand why they do that. Well, I suppose I do, in that they're pushing the settlement process, but I actually think it's quite unfair. And I think that those settlement notices should be issued by 2 o'clock at the latest on any given day. But suffice to say, that often happens. So when you don't hear until the next day from your lawyer as to the plans being registered, you might want to ask when they got that notice. It might have been late in the day. But in any event, it's a 14-day turnaround time. Important to check your contract. You might have negotiated at the beginning a longer time frame, like 21 days or 28 days or 30 days, particularly if you're interstate or overseas. So you always want to check that that is the correct time frame, because when developers' lawyers issue these notices, they do it as an automatic default across all lots in a building, and sometimes they miss these critical timing for your particular lot. That might happen by accident. So it's important to check that. So we've now got to that sticky point of I'll call it the 2 weeks, because 99% of the time it is that 14 days in Queensland. What happens in that 14 days? So this is the other steps that you need to understand. And this is where you as a buyer really start to get involved. So you've got your pre-settlement inspection. Very, very important. Hopefully you would have got advice from the beginning about what your contract says about a pre-settlement inspection and what your contract says about identification of defects, how the process works, and remedy of those defects post-settlement. So hopefully you've understood that, and you might have already got that advice, and then your lawyer will now remind you of what they advised you before. We do that. We actually give you a letter and we advise you of what is required. We also remind you at that critical time, which we did advise you from the beginning, that when you do your pre-settlement inspection, a few little tips. One, take photos and videos. Pretty important. So sometimes the agents there won't let you, but they should, because a pre-settlement inspection is critical to be conducted. And there's a few reasons. We'll explain that in a minute. When you go through your settlement inspection, your pre-settlement inspection, turn on all the taps, shower heads, white goods, fans, lightings, remote controls. Does the hot and cold water work on the correct side of the taps? Is there good water flow? In addition to all the usual things you're looking for, such as chips in tiles on the floor, or wooden floorboards, or door handles put on backwards, or not put on correctly, or painting not correct, or other types of defects. So we're not looking for structural defects. That's not the purpose. The purpose is to identify defects, faults in the workmanship generally of the fit out of that particular lot. Also, if you did negotiate any optional upgrades at any time, you want to know that those particular upgrades are actually included, because they'll be calling for those monies that you agreed to pay for those optional upgrades at settlement. So pretty important that it's actually included in your lot. So sometimes, and not always, the optional upgrades may be missed, or maybe they're not put in correctly, like the wrong color carpet. It's been known to happen in some townhouse projects near us at Hope Island, or perhaps they've just completely forgotten to upgrade. Now, that doesn't happen very often, but it's important to check those upgrades that you've agreed to with an additional purchase price have actually all been included. Now, it's important to understand what your contract says, because often the contracts, the off-the-plan contracts, create a detailed pre-settlement inspection process. And what a lot of them say, not all, is that if you go through the pre-settlement inspection, which you should always, and we'll get to those reasons in a minute, apart from the obvious what I'm saying now, is if you go through that process and you sign an inspection certificate on the day, which says either that there are defects, there are no defects, or there are disputed items. So you say something's a defect and the developer's representative says there isn't. So they're listed as disputed items. And if you go through that process, then the contract may say that you get another 90 days post-completion to do another or give another list of defects to the developer. So it's pretty important to understand how the process works. It's really essential. If for some reason you can't fly to the Gold Coast, if you live interstate or overseas, to do it, then you should have someone do it for you on your behalf, so it can be said that you did actually conduct that pre-settlement inspection, whether it's the agent, whether they do it via FaceTime or a friend, or whatever the situation is that you can organize. Because these contracts that give another 90 days to provide another list of defects often say, well, if you don't do the pre-settlement inspection, you don't get the second bite of the cherry, so to speak. So it's really important that you do it. Now, the other reason, this is what I want to get to, is from an evidentiary point of view. It's logical when you think about it that even if you get another opportunity after you've settled to give another list of defects, and you've moved into the lot particularly, then you can understand what I'm about to say, and that is it's far more easy to prove that there is damage or a defect in your unit before you take possession and before you move in your furniture. So something that a lot of buyers don't really think about. They go, oh, okay, I've got an opportunity to do it post-settlement, leave it at that. No, not really, for the reason I said before. In your contract, if it says that you have to do the pre-settlement to get the second opportunity to give a second list of defects, but also from an evidentiary point of view, how do you show that there is a defect there once you take possession? Now, yes, sometimes when you do the pre-settlement, it might be rushed, or the agent might be rushing you through, etc. Try not to be rushed. But if they do, yes, sometimes you might miss something. And it's only when you settle it and you're sitting in your lounge at nighttime or during the day and you're looking around the rooms and you're realizing, oh, I've just found another defect. I didn't let the developer know. Fair enough. That sometimes happens because you're more relaxed. You're looking around, you've got more time. But don't be fooled or tricked into thinking that you shouldn't do the pre-settlement inspection. It's very important from that evidentiary point of view. And you can say, well, this was here before I took possession. Therefore, it's on you, the developer, and not me. Okay, so really, really important to understand how that works. Now, during that 14 days, you do a lot of things, like I said, which is one of the big things is the pre-settlement inspection. Obviously, keeping in touch with your funder, doing all the things that you're required to do as well, which is very, very important. And you would have done a lot of things hopefully prior to settlement being called for, as I said before. But also we have to run around and do a lot of things for you, which is talking to the developers' lawyers, checking the settlement figures that they have provided for settlement for you. Now, that settlement statement is important for us to understand. If you have a lawyer that's not experienced in off-the-plan contracts, they may not understand what this settlement statement is, what it looks like, because it is different to settling registered lots, because you're going to have items in there like you do with registered lots or registered properties, such as adjustments for rates and water, body corporate levies, but they're going to be done a little bit different, because often when the project is complete, the lots are created, titles issued, the council would have not issued individual rates assessment notices yet for all the lots. There wouldn't be water assessments issued for the lots yet. Certainly there's no water usage, but also body corporate levies, important to understand how they're prepared and adjusted. And because we do projects, we act for developers, we are on the other end. We manage projects, we issue these statements to buyers on those projects that we have. So we understand how to do these figures. So then when we get the statements issued to us from other lawyers where they're acting for the developer and we act for buyers, we can actually understand these statements. And one of the, I'll call it a bit of a controversial issue, is how body corporate levies are adjusted. Sometimes in projects, the developer actually tries to adjust for the second year in advance. Now, it's a bit of a controversial point. It can be argued on both sides, but ultimately it'll come down to what's in your contract and how the wording is used to adjust for those levies. So under the legislation, the developer can recoup insurance that's paid up to the first year from registration. So yes, that's all allowed, but there are other potential adjustments that certain developers request. So it's important for your lawyer to understand that. The other issue is land tax. So if you are able to negotiate, as we often do, to get land tax adjustment removed from your contract from the beginning, then you should not have any land tax adjustment at all. If that didn't happen, then there will be a land tax adjustment. This is an adjustment that you pay a proportion of the developer's land tax, not your land tax, because you don't own it yet. So that's something that may be in your figures. And the other important thing with figures is to understand, well, what period are you paying for? Again, this comes back to getting pre-contract advice. So it always goes back to what did you get advice on and what did you negotiate from the beginning? So many off-the-plan contracts make buyers, or they dictate in the contract that buyers are actually liable from the time that the plan is registered for all of the adjustments, as opposed to from settlement onwards. We don't really agree with that particular process. We always ask if we can get the adjustments calculated as of settlement, meaning the buyer is only liable from settlement date onwards to pay for their share of the outgoings. Often that in off-the-plan contracts, developers want buyers to be liable from registration. Now, that sometimes can be a longer period than that 14 days I talked about before, because just because a plan is registered doesn't mean the developer will actually call for settlement when the plan registers. Typically they do, but they might be waiting for a certificate of occupation, for example. They might actually extend that time. So you might find that as a buyer, if you agree to that from the beginning, you'll be paying an extra 2 weeks definitely, but maybe 3 weeks, 4 weeks from when the plan's registered onwards for outgoings, which I just think is personally wrong. So buyers, hopefully you'll only be paying from settlement onwards for all your outgoings, your adjustable items. And also in your statement, if you've actually agreed to anything such as a variation, additional costs, that will be in your settlement statement. Another misconception, quickly I will mention, buyers often believe that they'll get the interest on a deposit with or at settlement in that settlement statement. Now that often doesn't happen because it's a bookkeeping and an accounting nightmare, basically, for a developer's lawyers to close all the investments in time for settlement and account for all the interest across each lot. And each lot might be different. You might have negotiated 100% of the interest on the deposit, which we often do for buyers. Maybe it's a 50-50 split. So often you'll find that that interest component is paid to you post completion, so it won't be in your settlement statement. But again, it's always prudent for your lawyer, as we do, to ask the other side, Where is the interest component? How will that be paid? When will that be paid? And then you get that answer. Now, just on outgoings, here is another little tip, something that only experienced lawyers look for. So in your off-the-plan contract, when it explains how outgoings work, you will want to have a clause in there that the developer gives an undertaking to actually pay the rates and water and other assessments issued when they issue. Because as I said before, when the lot is registered, there is no time for council to just issue individual rates and water notices. And there may not even be an individual land tax assessment notice. So often the contract says that in that case, there can be a post-settlement adjustment between the parties, and that's fine. There's nothing wrong with that. It happens a lot. But if that occurs, you still want your contract to say, and in that event, the developer gives an undertaking to pay those assessments when they issue their share of the assessments. And it's in the REIQ contract. It should be in all off-the-plan contracts. Believe it or not, that undertaking provision is not contained in all off-the-plan contracts. I just read one yesterday for a land subdivision somewhere up north Queensland, and there is no undertaking given. So there is no warranty given to a buyer that when those assessments issue, the developer will actually pay their share. So it's pretty important and pretty important to look for that. And that's what we do as part of the overall package of the services that we give to buyers. So when we get to settlement, we've already agreed with the figures. We advise you, we get all the monies in. So whether it's coming from your lender, we liaise with your lender, your funder to make sure they're ready for settlement. If you're tipping in cash, that comes into our trust account typically, and we will have that ready to go, and it will be settled on PEXA. Typically, it will be, unless you're doing an on sale. We've done an episode on sales, so I would encourage you to also listen to that episode on our YouTube channel about how you can on sell your off-the-plan contract. Those settlements at the moment are not available to be settled electronically in PEXA. They are paper settlements, different process again. But suffice to say, let's deal with you're doing an electronic settlement. It's a normal off the plan, a settlement between you and the developer. So yes, it will be settled electronically. So you would tip in the balance into our trust account. That's one option. And then we upload monies into the PEXA workspace, or you can actually tip it into your account that you've opened with your funder and give them authority to access surplus funds. So there's a couple of options there. Then we get to settlement. We settle. Great. Yippee, yippee, yippee. We're all settled and you're now the owner of a new lot. Fantastic. Congratulations. So we still are doing work. So really important, if you settle, whatever time you settle on that settlement date, 1 o'clock, 2 o'clock, 3 o'clock, 4 o'clock, which is the last time to settle, what your lawyer needs to have done is also be ready to issue a notice to that body corporate management company immediately. There are many projects on the Gold Coast here, particularly at the North End, Hope Island, where there's a security team waiting to give buyers access, and they're very vigilant, and they will not give buyers access unless they've been ticked off their list. And how they get ticked off the list is if they're told from the body corporate management company that day that settlement has been effected, and they have to be told by both parties. So really important that that notice gets issued immediately. We issue it immediately. Often what happens, it somehow gets lost in the body corporate management company systems. These companies are often quite large, and so whilst we do the right thing, they often don't pick it up. So we have to follow up with phone calls. But really important, between the hours of, say, 4 and 5:30 p.m., the buyer, your client, has to get access. So we make sure we get those notices out. Your lawyer should be doing the same once you settle. And then once that happens, great, you can move in, move your furniture in, or put it in the rental pool, have it as an investment, whatever you're doing. And hopefully you would have had a happy experience. So I trust that this has been another valuable episode for all of you interested in off the plan. It's a very interesting space to watch in this present current market and economic conditions we have, particularly in Queensland and on the Gold Coast. So please subscribe to our channel, listen to all of our episodes, and stay tuned for more episodes coming your way. See you soon.
Thanks for watching. If you found this content helpful, please like and subscribe to stay updated on property and various other law insights. Despina Prel brings almost 30 years of expertise to her YouTube channel, sharing knowledge gained from her extensive career including work with major Gold Coast developers and prestigious projects like Q1 and Palazzo Versarchi. As a member of the Queensland Law Society's Property and Development Law Committee, Despina offers valuable perspectives on legal matters affecting the property market. Don't miss out on future videos. Hit that notification bell to learn from one of the Gold Coast's most experienced property lawyers.